you're looking at the 10th century, Edgar, who's king at the end of the 10th century, who is a powerful king, and he is nevertheless someone who makes concessions. And one of them is he begins this practice of promising in his law codes to honor them, honor the very laws, and to not be abusive, not be a bad king. And that practice is followed by subsequent kings. The Scandinavian king, the Viking king who conquered England in the 11th century, Canute, actually creates probably a coronation oath, an oath the kings would take, promising to respect the laws of the land. And in his case, what he was made to promise as part of the deal by which he got England was to honor the laws of Edgar. So again, it's this backward-looking precedent. These are the good old laws. I will honor them. And you can follow that, hopping and skipping all the way up to Magna Carta, even over the Norman conquest in 1066. A dynasty, to call it foreign is wrong because they're cousins. But William the Conqueror fights a battle, kills the king, Harold, and takes over the kingdom. It's always a mistake to have a very centralized government. When they fall very fast. And for hundreds of years, scholars have tried to sort out, what happened. And one of the things I think that is interesting in terms of Magna Carta that happens is you see people taking a lot of pains to try to ensure that people feel comfortable that there's been a continuity of law and political power over the conquest, whether rightly or wrongly, whether that reflects reality. They create a concept of the laws of Edward the Confessor. And each king after, from William on, promises to honor those laws. And those are the laws of the last English king. Now, they don't exist. There was no code issued by Edward. But this notion that the Golden Age had produced laws that all English kings should honor is there. And so there again, kings putting themselves under the law, hearing the law from the people, and then putting themselves under it. And so one aspect of Magna Carta is that. It's just that you have a king, in this case John, who is put, though the document is from him, so he's sort of saying, I'm happy to do this, but put under the law, and with a lot of safeguards in place in that first Magna Carta. The only other thing I'll add, and this I'll revisit later when we talk, I think, about some of the common misunderstandings of Magna Carta, is that you should keep in mind, with all these legal texts, it's still very hard to know whether any of them is actually official as we would think of a law as official, something that people would go to as a source or reference. There's just a lot of law floating around, and when you look at what happens to Magna Carta afterwards, people start to adjust it, edit it, merge versions of it. It's really very strange. And so I think we tend to see it as this document that appears, it has these rights, and it comes out of nowhere, and it has an influence. Well, there's a long lead up to it, and there is a different context for understanding it that should always sort of be there when we're trying to interpret what it actually meant to people of the time.
That's great. Jenny, you want to talk about how we actually did it?
Well, it's one thing for kings to promise when they're crowned to follow the law, and it's quite another thing for them to do it throughout their reign. And that's where effectively the rubber met the road with Magna Carta, because we come to a particular king, King John, and John is one of only 2 kings in English history never to have a successor named after him. So there's never been a John II, and I can confidently predict there never will be a John II. That name is definitely off the list. You think about when they name a new prince, what are the names in contention? Not John. Now, there really are 2 proximate causes for Magna Carta. One is a foreign policy disaster, and the other is the character of the king. And I would argue that without those 2 factors, we would not have had Magna Carta. So the foreign policy disaster. Bruce mentioned the Norman conquest. What the Norman conquest did was to make England a cross-channel empire. So they've got England, and then they've got lands on the continent that they still control. And that's Normandy, where William the Conqueror came from. But over the course of the 12th century, they acquired basically the whole western seaboard of France. So they own basically half of France, which is great for the English, not so good for the French. So there is a standing conflict between the French kingdom and the kings of England. And it is exacerbated by the weird sort of feudal situation that obtains between them, because those lands in France that the English control, they are held of the French king as fiefs. So the French king is actually the overlord of the English king in his capacity as Duke of Normandy, Count of Anjou, etc., etc. Now, this is really a false position for two kings to be in regard to each other, because the sovereignties conflict. But they haven't sorted that out in the 12th and 13th centuries. And so it leads to a standing conflict of interest between them. There is fairly constant war between France and England in the French territories that the English control. They're always going back and forth across the border. And so now we come to the reign of John. John takes the throne in 1199 when Richard the Lionheart is killed in really a rather unimportant skirmish in the south of France in a territory that he controlled. You have John on the throne, and the King of France is immediately going to try to take advantage of the relative instability of the succession to seize some land. But they come to an agreement. Okay? Everything is going to be fine, and then John gets married, and that screws everything up. It's one of the most disastrous marriages in English history for a number of reasons, but one reason is because of who the bride is, and particularly because of where she comes from. This is Isabel of Angoulême. Angoulême is a small territory in southwestern France. The problem with Angoulême is that it adjoins the county of La Marche. And La Marche was ruled by a family that were constantly rebelling against King John. Now, John did not want the Count of La Marche to marry Isabel of Angoulême. They were engaged. So he wanted to block that marriage because he feared that if these two territories were united, then there would be this big indigestible block of rebel territory in the heart of his French dominions. So he doesn't want this marriage to go forward. So what is his solution? He marries the bride himself. He scoops in, takes the bride, marries her himself, and oh, by the way, they had been postponing this relationship, the Count of La Marche and Isabel, because the bride was 12 years old. But the king marries her anyway. Now, this might have been okay if the king had compensated the Count of La Marche for stealing his fiancée. But John was just the sort of guy not to do that. It would have been much better if he'd say, well, I'm sorry, I took your fiancée, but here is some extra land, here is a payment, it's all good. He didn't do that. He basically thumbed his nose at his own vassal, and that caused the Count of La Marche to appeal to the King of France. Because, of course, the King of France is the overlord of both the Count of La Marche and the King of England. So he appeals to the King of France, and the King of France has just been waiting for an opportunity to do something against King John. And here this is delivered to him on a silver platter. Because, of course, John has violated the rights of his vassal in taking the fiancée without compensation. And so the King of France confiscates the lands that the King of England owns in France. And then he actually makes good on the confiscation by force of arms. And he invades Normandy and he conquers it. Now, the King of England has lost all the land in France, or lots of it, okay? And particularly the land that people actually cared about, Normandy. And this is a complete disaster. Kings of France, or kings of any kingdom, are not supposed to lose land. If anything, you're supposed to increase it, not lose land. And now John is in a bind because he has to try to get the land back. He needs to pay for the reconquest. He can't pay for it because now all of a sudden he's not getting any revenue from that land anymore. So he has to tax England unmercifully in order to pay for the effort to get the land in France back. So he is now in a vicious circle because the more he taxes England, the more they hate him. Okay? But he has to get the land back or he will lose face as king. And it goes on like this for about 10 years. In 1214, he basically makes one last effort to recover the land in France. He gathers together a coalition of continental allies, in particular his nephew, who is a German nobleman. And he's going to do a pincer movement. So his allies are going to come into France from the northeast. And John is going to land in Poitou in the south on the coast. And then they're going to meet up, head towards Paris, and get the King of France sort of in a vice. But it doesn't work, okay, because John is bottled up on the coast. He can never meet his ally, so his ally has to go up against the King of France alone. And there is a battle between the King of France and this German ally, and the French win the battle. And the battle is called the Battle of Bouvines, and all commentators on Magna Carta will agree that there is pretty much a straight line from Bouvines to Runnymede, because the barons in England are basically waiting on the sidelines to see if John is successful. If he is, maybe they'll forgive him all the other stuff he's done. But if he's not, they're done with him. And this battle takes place in July of 1214. In the fall of 1214, the barons are already gathering together to talk about what to do about King John. And by the spring of that year, they are actively discussing some of the issues that end up in the draft of Magna Carta. So that's the foreign policy cause for Magna Carta, but there is also a character cause for Magna Carta, which is the fact that John was detested widely by his barons. He was regarded as untrustworthy, vicious, cruel. He was just the sort of person who you would have to extract promises from because he didn't keep his word. He was basically well known for that. He was somebody who acted arbitrarily. One of the things that he did to raise money for this continual effort to recover land in France was to fine people arbitrarily for offenses that sometimes were real and sometimes invented. He would lend money to people in unrealistic amounts and then have the debt hover over them. I mean, so people were always scared of what John would do. He was very unpredictable and really just the best example, I think, of the kind of cruelty that John engaged in. He got into a dispute with one of his vassals named William de Brieuze, and he actually had the wife and son of this vassal starved to death. Okay? And this was widely known. All the chroniclers of the time report it. It was widely known. So that was the kind of thing he did. And he also would go around to the castles of his barons and demand to sleep with their wives and daughters. This is the kind of man he was. So this is the kind of person who you would definitely want to promise on parchment that he was going to be a good boy.
Now, Bruce, you mentioned before, it's sort of anomalous that this became such an iconic document in the United States, and I guess part of it, maybe you can also talk about the reinterpretation by Edward Coke and the impact of the English Bill of Rights in this country then. But
sure, it's actually an interesting tale, and it's pretty straightforward. At one point, strangely, I ended up teaching the American Revolution in graduate school at Yale. Ed Morgan was there, and they were desperate. The Americanists were all off doing work, so he said he'd take anyone who could stand and read, and I could do both. But I had to bone up on American history because it had been a few years. And what I realized in doing that was there was this interesting connection between Magna Carta through the Petition of Right to the Bill of Rights, to the colonial petitions, to the Constitution. And that's actually, I started my students that semester with Magna Carta. They were a little puzzled that was their first reading. And the reason we see the link is textual. Each of those sources is citing the earlier source. But what happens to it in the 17th century is pretty remarkable. This is England coming out of the Tudor period, which is exactly like the TV show, The Tudors. Oppressive, violent, driven by personal motive. And the Tudors were monarchs who believed in their own power. They thought that they were, in fact, quite the best thing around. And they weren't going to be troubled by the niceties of parliamentary precedents that had been built up over many decades. And they're powerful kings, so they did what they wanted. And Elizabeth is not that much different from her father, Henry. So England in the 1500s is a period where you have a lot of smoldering resentment amongst people who operate in the law, people who operate in the state, not just religious dissenters or Catholics, but these folks. And they began to consider, what they could do. And a lot of them gathered in London. They were associated with the Society of Antiquaries. Sounds very tame, kind of a thing to go, a sleepy place to retire to after your active life. But it actually was a hotbed of revolutionary zeal. And the members there would read old documents. They would read old laws coming back from the Anglo-Saxon period and all the way on through Magna Carta and then laws that have been passed since to try and figure out what their strategy should be. One of them, Edward Coke, ends up as Chief Justice. And he rules in a number of cases in such a way in the 1606 to 1616, somewhere around, that's when he serves, in such a way as to reinterpret Magna Carta. Magna Carta is a very narrow partisan document. The people who draw it up benefit from it. The same kind of argument was made about the American Constitution by Charles Beard many years ago. It's partly true and partly not. The barons were very interested in themselves, and so when they talked about people, they were really thinking of well-to-do people. They were thinking of free people, not the unfree. They were thinking of men, not women. That's kind of where they were. And Coke, in changed circumstances and a changed notion of what justice was, rethought it and said, we're going to extend this as a precedent to all men, to all people, not just to, in fact, this very narrow clique. And so in a number of rulings during that period, he did so. That led to, part of that was the Petition of Right, which followed, which was asking the king of the time to, in fact, honor a number of the basic items in Magna Carta that show up there. Those later get expanded on in 1688-89 during the Glorious Revolution to the Bill of Rights, the English Bill of Rights. You can't quarter troops, due process rules. It's all kind of there, all of the legal principles burnt out. And that's what the Americans get, because that's when they're settling. That's when they're coming over and colonizing. They have libraries, they have books, they have Cook's commentaries, they read them, they apprentice at law in the same way that it's a similar kind of way that they do in England. And so they're keenly aware of that tradition. That is their heritage, and it's in their charters. And so, there's this, it's all one culture at that point. And Coke is huge for giving them a new way of thinking about Magna Carta.
That's exactly what I was looking for. Rob, why don't you talk a little about, let's start with Magna Carta's influence on the colonial charters, because that's where it really started here. And go from there to the pre-revolutionary period, I guess. But
okay, so the language of the Magna Carta was reproduced in a number of the colonial charters. In at least one colony, the colonial governor reviewed legislation to make sure that it comported with Magna Carta. In the sort of the discourse, as far as we know of the time, people talked about claiming the same rights that Englishmen had. After the Revolution, they wouldn't speak in those terms, but before the Revolution, they did. So all of that was happening before we had the series of documents that we talk about as our founding documents, the Declaration of Independence, the Articles of Confederation, the Constitution, and including the Bill of Rights portion. So in the Declaration of Independence, there's an obvious similarity because they're listing a series, or they're creating a series of complaints about the king, and in this case, justifying why they're separating from the king. So the war is just starting. In the Declaration of Independence, there are some statements that refer to not only the Magna Carta, but the lineage of the Magna Carta. For example, when it says that the king has created a jurisdiction foreign to our Constitution, the writers are talking about how the principle of the authority being subject to law was not being followed. And of course, our Constitution didn't mean a specific document. It meant all of the principles and customs that English law followed. So that's the Declaration of Independence. In the Constitution itself, there are several references that also connect to the Magna Carta. The first one is in Article 1, listing out the powers of the national legislature, where it says that the privilege of habeas corpus will not be suspended except by Congress and except in very limited circumstances. I should explain just really briefly that habeas corpus is a form of pleading in which you request to be brought before a court so that you can show that you're unjustly confined by the state. So that's why a lot of people talk about habeas corpus as sort of the most basic right as against the government, because it allows you, no matter what the circumstances of your confinement, to come in and say this fact of confinement is unlawful and I must be released. So you go back to Article 39 that Judge Lamberth mentioned earlier, that says that no one will be taken, the king will not go against anyone except by law of the land. And so the law of the land meant that if the confinement was unjust, then you ought to be able to appeal it. You ought to be able to seek relief from it. And this was true whether you were simply captured by the government, whether you had been tried and convicted and had exhausted all of your appeals so that appeals were no longer possible, whether you were captured and not charged with anything. And I'm jumping ahead a little bit, but that's the situation of the Guantanamo detainees today. And when we talk about the legacy of the Magna Carta in our time, I'll say more about that. But so habeas corpus is a form of pleading, and it is the procedure that allows many state detainees to go free, both in England in earlier times and right through to today. So in Article 1 of the U.S. Constitution, there is this provision that states the importance of habeas corpus, which connects to Magna Carta, as I've said, and says that it can't be suspended except in very limited circumstances. Then there are the provisions granting a speedy trial, trial by jury, and due process. All of those are reproduced in the Bill of Rights part of the Constitution. So there are two due process clauses in the U.S. Constitution, both the 5th and the 14th Amendment. So the 5th was adopted as part of the original Bill of Rights, the 14th Amendment after the Civil War. Both refer to due process, and again, we'll say more about this later, but due process is another way of saying law of the land. Incidentally, if you want to talk about how the Magna Carta continues to influence law today, and I literally mean today, Julie told me earlier that the Supreme Court ruled this morning on a case called Kerry v. Dinn, and that they cite the Magna Carta for this very principle, that due process means law of the land. So the due process clause has a direct textual connection to the Magna Carta. And then, of course, there's the right to jury trial, because Article 39 and 40 say that you can't be imprisoned or punished except by lawful judgment of your peers or by law of the land, and that to no one will be delay or deny justice. So each of these refers to trial by jury, respectively, and the right to a speedy trial as well. So these are provisions in the Bill of Rights. So you see that in the Constitution itself, we've enacted language that operationalizes these guarantees that are set forth in the Magna Carta, and they become directly part of our law. And of course, since we do have a written Constitution, unlike Britain, right, so lawyers will cite to these provisions and even use these rights as a source of an action many times in court.
And Bruce, I take it that a number of state constitutions enacted at that time did the same, relied on language from the Magna Carta and the English Bill of Rights.
It's certainly in a lot of the colonial statutes and charters. It's in a lot of the charters, and is something that through the 1600s is well known to all throughout the colonies, Georgia all the way up to New Hampshire. So this is something that is, again, I don't think it's all that different initially than what someone in England might have felt. But it's the increasing alienation of the colonies that gives it more freight, because they start going back to these because those are the things that are challenged by the English monarchs. They say, well, hold on, what is our charter? And it starts to actually take on a new life for them.
Good. You also, Bruce, were talking about the myth of the Magna Carta. Let's talk a little more about what the myth is.
Well, a couple things to say here. One, myth is not a bad word, right? Myth is. I was reading the op-eds today, partly out of vanity. I got to do an op-ed for the first time. No one asks medievalists to do op-eds, so this is it. This was it. I was seeing there's a lot of very similar kinds of things, but people were talking about the myth, and I don't think I used myth, and as if it were a bad thing that I'm going to expose this document as something like a fairy tale. Well, myth actually isn't that. It's a powerful story in some way. It's something that maybe takes on power outside of its mere words. You could say the Bible has mythic qualities to it. This is fine. So when I use myth, I'm meaning it in that sense. I think we tend to, as Americans, miss some things about Magna Carta that are kind of, they're in the footnotes, so to speak. But they're the kind of interesting things that I think make it come to life. And these, instead of demythologizing it, I think you just keep these things in mind and say, well, this is a human product. Human society is complex, and what it produces is a reflection of that. Well, Magna Carta is a statement of principles, about due process. Robert was talking about due process, the key one, chapter 39. But it also includes several chapters. Chapter is just, might be 20 words that describe something, that draw their text from a early 12th century forgery by Geoffrey of Monmouth, which is about the kings of Britain and Arthur. And this is what people are reading, and they're reading it in Latin, they're reading it in translation. It's available in French at the time, and somehow words make it into the final document. So that's kind of interesting. And then the second is that a number of the key principles about the king being just are first found not in the various drafts and documents, the barons. We can actually track their process of writing Magna Carta. It's really fantastic. You can't do that with many documents. But the earliest document where we see that stuff taking form is something called the Laws of the English, the Leges Anglorum. It is a forgery. It claims to be the laws of Edward the Confessor, which it is not. And someone has put in Arthur, who is a great legislator and conqueror, has put in all these maxims about how kings ought to be just and ought to rule by right, and a king who does not rule by right is no king at all, and so on. But it's a forgery that they're including it into. I don't know if they know it isn't a law code per se. So that's kind of interesting. The most radical parts of the Magna Carta get cut out. So we get the stuff that, through the tests of time, which means politics, the things that survive through politics, like due process and jury trial, we get those now. But at the time, Magna Carta had a clause for enforcement that was quite revolutionary. The barons would form a council, and when the king misbehaved, they would basically appoint a posse to go after him and rustle his cattle. Or that's the process called distraint. We're going to take a lot of your property until you behave, John. And so they have that all worked out. And John agrees to that. Now, that gets cut out immediately. And war starts. But, that's a remarkable thing. It's pretty remarkable what survives, but that's even more remarkable. And then the last thing I alluded to earlier, we tend to think, because we're a very text-oriented constitutional culture, as Robert has mentioned, the British don't have a constitution, and it works out okay over there. They've done all right over the centuries. But we think it's very important to have everything in writing. And so we think of writing as here are the words. Here is what the king and the barons agreed. These are what was said. Well, if you look at what happened to Magna Carta after it was issued, so 1215, they agree to it, gets sealed. Copies are ordered to be sent out. Then they're immediately annulled by the Pope, who basically considers John a vassal. 1216, it gets reissued as a way to end the Civil War. 1217, And then 1225 is the big one, and then there's the one in the 30s, and there's one in the 50s maybe. It gets reissued a bunch of times with different chapters. And that's confusing enough, because there is no point where someone says, well, hold on, that's the old edition. You can't cite that in court. Creative scribes began to combine them, taking the parts they liked and dumping the parts they didn't. So anyone walking into a library in, say, 1230 and saying, well, I've heard about Magna Carta in Rome. I came all the way to see what a fantastic... Well, they say, which version? We have like 30 or 40 different versions of it. And they didn't sort out which king had signed it for 500 years. They thought it was Henry III, not John. And so again, it's in Cook's day, or actually after Cook, it's in the 1700s that they sort that out. So it's a document, but not kind of like our Constitution in that sense.
You had some skepticism, Jenny, about whether it's worked better in England or here.
Oh, I don't know if this is the occasion for that when we're all talking about Anglo-American friendship today. So.
Rob, you want to talk about the myth?
Sure. I mean, as Bruce was saying, there are a lot of different dimensions to myth and a lot of different ways of understanding what a myth is. But in one specific sense, people have written... Edward Jenks in 1904 wrote an article basically saying that this was not a document that spoke for the common people. This was not an origin of cherished rights. It was simply an agreement between one wealthy person and a group of other wealthy people. And I mean, it's pretty clear that you can't disagree with that on those specific terms. But like the U.S. Constitution, we have a constitutional culture that incorporates a number of myths, including the myth that we were born a free nation, right? There were some people who were very much unfree when the nation was born. So I guess my take on the question of the myth is that it's undoubtedly correct to say that there are a number of mythic things about the Constitution, but that for...
Sort of like the myth that all men are created equal.
Right.
Did not include
exactly right, Judge Lambert. So yeah, but at the same time, we can utilize that myth, and it can still shape our law, and we can move toward a position in law that's actually closer to what the myth was stating.
I had another question I wanted to ask all the panelists, and that is, what do you think is the continuing influence of Magna Carta today? And we'll talk about some specific things, for example, executive action. Rob, you want to talk about that one first?
Yes. So first of all, I mean, there are some real concrete, specific questions today about executive action that force us to ask really what is the executive subject to law, which is the basic thrust of Article 39, right, that the authority is subject to law. You can take the example of drone strikes, for example. This is a due process question in the sense that something's being taken away from people, namely their lives, without a hearing, without any kind of judicial ruling, but simply as a result of internal deliberations within the executive branch. So the Obama administration has explained that to them, due process doesn't always mean judicial process. In other words, due process is a flexible concept. Any lawyer will tell you that, but that in fact it's so flexible that it can be stretched to say that you can deprive someone of their life without going to a court. The deliberations that suffice to be due process can take place completely outside of a court and without any judicial official being involved. And this is something I think we need to talk very seriously about, because what does due process mean if the executive can take life without a trial? I mean, that sort of directly contradicts what Article 39 says.
The barons certainly didn't think that's what they were doing with King John, did they?
I think they would have had a problem with that, yes. And then there's something that some legal theorists talk about, which is a state of emergency or state of exception. So back in the earlier 20th century, Carl Schmitt came up with this theory of a state of exception and basically said that there was always a space beyond law in which the executive had to operate at certain times. And so the executive was normally bound by the restrictions of the Constitution in a constitutional republic, but that sometimes that state of things had to be suspended, and we moved into this other space beyond rules, beyond constraint. For the executive. Obviously, this is a fundamental problem of legal theory, because once you say the executive is not bound by law, not only are you going against this core principle of the Magna Carta, but you're also in a sort of, there are no limits, essentially. Some legal scholars have struggled with this idea, trying to come up with a model of what would an emergency constitution look like. Bruce Ackerman has said that we could have an emergency constitution that kicks in at a certain point, and then it would suspend certain kinds of limits on executive power, and then for it to continue, it would have this is quite a mouthful, but a supermajoritarian escalator, which is classic academic jargon, but it's not a thing in a shopping mall. It's actually a principle that says the longer the state of exception goes on, the larger the supermajority that has to approve it. So scholars have grappled with this idea, and particularly after September 11th, if there's going to be a state of exception, an emergency constitution, what triggers it, how long does it last, what rules apply? And it's one of these tantalizing problems, because once you admit that there are no limits, how do you put limits back in? So that's the sort of one of the conundra of executive authority in our time, looking back to this basic principle of authority is subject to law.
That's an excellent answer. I appreciate that. Jenny, talk about jury trial and how Magna Carta is obviously, from my opening comments,
well,
I think it's had a great influence in this country.
It actually belongs sort of in the category of the myths of Magna Carta, because the word jury does not appear anywhere in Magna Carta. So the idea that Clause 39 of Magna Carta guarantees the right to a trial by jury is actually a much later interpretation of Magna Carta. That's not what anybody thought in 1215. It's a really interesting example of how two phenomena can coincide in time and then over a period of time actually coalesce. So what you have is Magna Carta being agreed to in 1215, and that very year you have a huge event in the Catholic Church called the Fourth Lateran Council, where Pope Innocent III, who annulled Magna Carta, gathered together a huge assembly of bishops and other church leaders and hashed out a number of very important issues before the church at the time. And one of the things that they did was to ban clerical participation in the judicial ordeal. Now, probably a lot of you have heard of the ordeal. This is where people are forced to walk across hot coals or hold hot irons or be thrown in the water, and if the water accepts them, if they sink, then they're innocent. If the water rejects them and they float, then they're guilty. Of course, you have to fish them out in time if they're innocent before they drown. This is something that people make fun of now. I mean, there's a wonderful scene in Monty Python and the Holy Grail about the judicial ordeal. But this was very serious business in 1215. A lot of decisions about guilt or innocence across Europe were made on this basis. And the church had grown uncomfortable with it and withdrew its approval. And this almost immediately caused the ordeal to wither on the vine. And they needed something else to put in place in order to decide guilt or innocence in criminal cases. Now, interestingly, on the continent, what they came up with was the inquisitorial process. Okay. In England, they went in a different direction. And by the way, that involves torture. Right? In England, they never embraced torture. Instead, what they came up with as a fix was the jury trial.